part of access to justice?
May I-
Is that part of independence of judiciary?
It is.
Fundamental rights. Fundamental rights. अभी आप देखें अमेरिका में कितना वो बना हुआ है, वो जो है आपका राइट ऑफ अबॉर्शन, वो कहाँ लिखा है कॉन्स्टिट्यूशन में? लिखा है उनकी कॉन्स्टिट्यूशन? नहीं लिखा था, वो राइट दे दिया, पेनम्बरा में आ गया ना। उसके बाद उन्होंने कहा, वो ओरिजिनलिज्म पे लोग जा रहे हैं कि जी बस आप देखिए उसके अल्फाज में लिखा है तो लिखा है, वरना नहीं लिखा, और वो भी जो 200 साल पहले की इंटरप्रिटेशन है। Is this the state of the law in Pakistan?
It is not.
Is the state of the law in terms of even full court judgments? But as a full court, as the Supreme Court, as the defenders of the Constitution, the question is, are we to allow any erosion of independence of judiciary, access to justice, and would that not be the grossest violation of fundamental rights?
Need, my lord.
With respect, अगर देखें सिद्दीकी साहब, I not, मुझे अभी तक आपके खूबसूरत दलाइल से मैं मुफीद नहीं हो पा रहा हूँ।
I agree, sir.
आप जरा अपने दलाइल अपनी मर्जी से कर लें। आप सवाल नोट कर लीजिए, आप हर चीज पे कमेंट, आप अपना दलाइल तो देना चाह। फिर आप कल आप कहेंगे कि मेरे दलाइल ही नहीं सुने जा करके। आप चलें थोड़ा बढ़ाने आगे बात को।
With great respect to my brother, independence judiciary is not just the external aspect. The most important is internal independence and institutional independence. अब आपने concede कर लिया कि this is a law which actually secures the internal and institutional independence. So, ओहो,
आपने कहा
एक
खाली तरीका ठीक नहीं
सेकंड, अच्छा लॉ है। इंटरनल और इंस्टीट्यूशनल इंडिपेंडेंस क्या होता है? अगर एक चीफ जस्टिस के पास इख्तियार हो और वो इख्तियार इस्तेमाल हो सके to achieve certain outcomes in cases and by constituting benches, that is a complete erosion of independent judiciary. And this is an aspect which this court has never taken into consideration. So that is, dunya bhar mein, this is the most important aspect of independence of judiciary.
आपको पता है बाकी मुल्कों में क्या होता है? जुडिशियल कैलेंडर स्टार्ट होने से पहले फुल कोर्ट बैठता है और वो बैलेट से बेंचेस बनते हैं, चीफ जस्टिस नहीं बनाता। और बाहर अगर आप ये बात करें कि चीफ जस्टिस बेंच बनाता है तो वो शायद इस बात को एक्सेप्ट कर सकते हैं, या बैलेट होता है या रेफल। कंट्रीज लाइक नेपाल, स्टार्ट ऑफ द कैलेंडर ईयर पहले बैलेट होता है कि बेंचेस कैसे होंगी। चीफ जस्टिस का कोई इख्तियार नहीं कि केस आज आया है और कल मैं अपनी मर्जी का एक बेंच बना दूं इस केस को सुनने का, जिसको मर्जी में बिठा दूं। ये चीजें, ये सारा कानून जो है ये वाजे कर रहे हैं इन चीजों को, इंडिपेंडेंस को तो बेहतर कर रहा है, स्ट्रॉन्ग कर रहा है।
आपने रूल्स बनाए हैं, उस रूल्स की बात की जा रही है। आपकी जजमेंट अपनी है।
जवाब दे रहे हैं, आप दलाइल नहीं देना चाहते हैं, आप जवाब ना दें, दलाइल दे दें।
आप इस तरह कीजिए कि आप अपने दलाइल
एस्पेक्ट अभी जो आप बात कर रहे हैं,
आप अपने दलाइल मुकम्मल कर लें।
वर्ड आर्टिकल 191 में लॉ लिखा है, whereas for example in relation to the review jurisdiction उसमें act of parliament लिखा है। It seems to me that even now if you go literal text of the constitution, that there is presumably a difference between the two, and law is in a common law tradition like Pakistan is well understood to mean statute law and judgment or case law.
Yes.
Now, Article 199 sets apparently a hierarchy. First is constitution, fundamental right, independence of judiciary. Next is law. Now, if law means, is the question to you, if law means statute law and case law, the two are then co-equal because both are incorporated in law. So the question that strikes me is that this whole principle, rule, whatever you want to call it, that the Chief Justice is the master of the roster, in fact is not in Order 11. It is given in judgments of the Supreme Court, in law. So the question therefore is, can Parliament, which is operating at the same level, law co-equal, so can Parliament make in the context of Article 191, and this goes to Section 8 of this particular law. Can it make a law overriding in relation to the practice and procedure of the court, judge-made law, which is at the same pedestal? Can they do that?
No, they cannot.
Seems to me
Imtiaz
that even
Saab.
if we literally look at Article 191, perhaps
Imtiaz Saab.
it is unconstitutional.
जैसा फिर अगर आपको कोई दलाइल नहीं देना है और नहीं आप सुन लीजिए ना, आप तो हर का जवाब ही दे रहे हैं, तो आप अपनी पिटिशन तो आर्ग्यू नहीं कर रहे हैं, मुझे नहीं लग रहा है। आप कोई दलाइल आप दलाइल देके खत्म कर रहे हैं, फिर आपसे सवाल पूछ लेंगे, आखिर में हमारे जहनों में होंगे, ठीक है, या हम अपने जजमेंट्स में लिख देंगे, हर जज अपनी राय लिख देगा अपनी मर्जी से। आप प्लीज अपने दलाइल दीजिए।
May I proceed on
जी प्लीज।
Sirf, I'll only make one observation. It is settled law by Noah that the Parliament has the power to make our judgments ineffective, and this is a precedent जो कि is embedded in our constitution.
if they are lawfully empowered, if the parliament is lawfully empowered, not otherwise.
फिर आप बहस करने लगे।
But surely that
आप सुन तो लीजिए ना बात को, फिर आप नोट कर लें भाई, आप आर्ग्यूमेंट्स होते हैं,
साहब, may I
आप
proceed?
जज नहीं
May I
हैं, आप
proceed?
हर चीज का वैसे जवाब दे रहे
May
हैं।
I proceed?
प्लीज डू सो।
आपको इसके एक जरा supplemental
आप चलिए, शुरू कीजिए, बिस्मिल्लाह कीजिए।
My learned brother asked you, surely that rule that Parliament can override judgments of the Supreme Court does not apply to a judgment which is interpreting constitutional setting or interpreting the constitution or setting or establishing constitutional law. That only either can be done by constitutional amendment or if the court itself revisits that view. I thought that was also settled law.
Yes.
तो देखिए साहब जरा सिद्दीकी साहब एक क्वेश्चन, आपका कहना ये है कि 3 मेंबर्स अगर बैठ के बेंचेस बनाएंगे एज पर दिस लॉ, तो ये इंडिपेंडेंस ऑफ जुडिशरी पर के खिलाफ है। तो क्या हम 17 जजेस बैठकर जब रूल बनाएंगे, हम कोई ऐसा रूल बना सकते हैं जो जुडिशरी की इंडिपेंडेंस को लेके एक शख्स के हवाले कर दे, या ऐसा रूल बनाएं जो कॉन्स्टिट्यूशन के, क्या हम ऐसा कर सकते हैं?
सर कर तो सकते हैं, आपने अगर एक बंदे को
अनलिमिटेड पावर्स है।
My lord,
जस्ट वन may I request my brothers, इनको बहस तो करने दीजिए, हम सब सवाल बाद में कर लेंगे। आप प्लीज अपने हिसाब से अपने आर्गू कीजिए।
See, Mr. Siddiqui, if I may just add, it is not a question of ये law गलत है या ये law बुरा है या अच्छा है. The fundamental question here is of competence.
Yes.
Who is competent to make whatever it may be called the rules of the law? If
ये तो आपने आर्ग्यू ही नहीं किया अभी तक।
competent,
तो मैं ये तो कह रहा हूँ,
आप हमें रोकें, आप कहें मुझे आर्गुमेंट सुन
सर,
लीजिए।
मैं तो कह रहा हूँ कि कॉम्पिटेंस नहीं है पार्लियामेंट।
आप बताएं ना, हमें शिक दें कायरीन की।
प्लीज आर्गू।
डायरेक्ट उसी पे आ जाए मेरे ख्याल में।
इसी पे आ जाए, यही सवाल है।
देखिए मैं आप देखिए, आप हमसे ज्यादा समझते हैं, वकील हैं, यकीन हम लोगों की अपनी अपनी राय हैं, ठीक है।
मुझे आप
जरा सुन लीजिए ना 2 मिनट जी। वो हम अपने, अगर हम एक दूसरे से इत्तेफाक नहीं करेंगे, अलग अलग राय लिख देंगे, ठीक है। मेरे हिसाब से मुनासिब नहीं है कि हम सवाल के तौर पे अपनी राय आपको दें और फिर कोई हम दूसरा जवाब दें। हम सिर्फ सवाल पूछ रहेंगे आपसे, आखिर में आप अपने दलाइल दे दीजिए, हम उसको नोट कर लेते हैं। हमें पसंद नहीं आए तो फिर हम सवाल, इतने पसंद आए शायद सवाल ही ना पूछे, नहीं पसंद आए 2-4 सवाल पूछ लेंगे। अब आप बिस्मिल्लाह कीजिए जी।
Lord, the concept of trichotomy of power is a concept well known to your lordships. The Constitution, what are those provisions which relate to the trichotomy of power, and let us have a look at them. With reference to the Supreme Court, have a look at Article 176, my lord.
जी,
Article 176.
जी पढ़िए।
My lord, Article 176 says, the Supreme Court shall consist of a Chief Justice, to be known as the Chief Justice of Pakistan, and so many other judges as may be determined by Act of Majlis Shura, Parliament, or until so determined as may be fixed by the President. What this article says is that one of the first steps the appointment of the Chief Justice is the centrifugal force, is the linchpin. And once he's appointed and the rest of these members are not appointed, the Supreme Court will be there. And then the judges will be appointed.
Please chaliye na, don't state the obvious, it's written there. This is really, no, sorry to say, आपको पता है अवाम कितनी पैसे खर्च कर रही है
सर मैं
आप ऐसी बातें तो ना करें हजूर
सर आप मुझे आर्ग्यू तो आप एक तरफ कहते हैं आर्ग्यू करें दूसरी तरफ आप मुझे
आप कह रहे हैं ये आपने पढ़ लिया
I am just giving your
interpretation of the obvious. Supreme Court comprises of Chief Justice and judges of Supreme Court. Obvious.
No, it is not.
It's not.
It is not. But I am giving you, your lordship, a circumstance that let us assume, to understand the dynamic of Article 176, that assume there's a Chief Justice and there's no other judge. The question is, will the Supreme Court come into existence? The answer is yes.
I will not answer your question. We are not here. We are not here in a theoretical realm. Please don't. No, now this is not fair. We are not here in a theoretical realm to discuss what may or may not happen. We are faced with a particular law. You challenge that law. Argue that case.
Let us proceed further. Let us go to Article 87. Article 87 relates to the Parliament and the Senate. Each house shall have a separate secretariat. This provided that nothing in this clause shall be construed as preventing the creation of posts common to both the houses. Sub-Article 2, Majlis Shura Parliament may by law regulate the recruitment and condition of service of person appointed to the secretarial staff of either house. Until provision is made by Majlis Shura under clause 2, the Speaker or, as the case may be, the Chairman may, with the approval of the President, make rules regulating the recruitment and conditions of service of person appointed to the secretarial staff of the National Assembly or Senate. So this is the rule-making power. Let's go to Article 67.
I will not allow it, and I might even start imposing costs. Let's go here, let's go there. What's the relevance of Article 187? Don't do this. Sorry, please don't do this. Please don't do this.
It shows that the Parliament as a separate organ of the state
profound
as the power to make rules for its internal working. And this is the theme which is contained in Article 67.
No. ये रूल्स सिर्फ बनाएंगे किसके लिए? सेक्रेटेरिएट
हमने तो नहीं बनाए लिए।
अपॉइंटमेंट के लिए, रिक्रूटमेंट के लिए और उसके लिए तीन चीजें लिखी हुई हैं साहब।
सर मैं आपको शो ये करना चाह रहा हूँ कि पार्लियामेंट का अलग सेट ऑफ रूल्स है, एग्जीक्यूटिव का अलग है, सुप्रीम कोर्ट का अलग है, और ये रूल्स जो हैं
आप सुप्रीम कोर्ट वाले पे आ जाइए ना। हम पार्लियामेंट के रूल्स जब वो चैलेंज करेंगे ना आप कि उन्होंने गलत बनाए वो देख लेंगे। अभी आप सुप्रीम कोर्ट पे आ जाइए।
सुप्रीम कोर्ट के रूल्स हैं आर्टिकल 191,
उसकी तशरीह कर दें, खत्म।
ठीक। Subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the court. Now, the law is a word which is different from the act of the Parliament. It may...
Law is different from act of Parliament?
Yes, it is. Law is
this is something I've never heard before.
Yes, sir. Allow me to assist you. Law encompasses a lot of other things than the act of the Parliament. Law includes with it itself usage having the force of law. Refer to Article 8.
In the same sentence, the Parliament Ain has used Constitution, law, and rules. And please, I'm not going to expect this kind of argument for the Supreme Court. Sorry, this is not on.
I'm giving your lordship extraordinarily good argument. If your lordship is inclined to ridicule me like that, I will not. I will withdraw from the case. I don't choice.
इम्तियाज साहब,
I don't allow this.
Please,
Imtiaz
that's your
Saab,
choice.
Your
Imtiaz
Lordship
Saab.
has constantly
Imtiaz Saab.
thwarted my arguments again and again. Have a patience to hear my arguments.
अच्छा ये बताइए जो बेचारे लोग जेल में पड़े हुए हैं ना एक छोड़ेंगे नहीं हम
मैं बचा रहा हूँ, मैं से ही हूँ।
हाँ नहीं
मैं भी नीचे से
केसेस कौन फैसला करेगा? एक चीज होती है अमेरिकन आइन में वो लोग करते हैं क्या होता है फिलिबस्टरिंग कि जी चलते रहो अगर आप समझ भी रहे हैं कि इस तरह से
मैं ऐसा कर ही नहीं रहा।
अब आप
अभी आपने मुझे
अब आप बोलने आपको हम सुनते हैं मगर आप हमारी बात को सुनना पसंद नहीं फरमाते हैं
सर,
तो ये
देखिए बात आधे घंटे से सुन रहा हूँ।
अच्छा चलें
If I've got you correctly, if I've got you saying that law is not only the act of the parliament, because there are rules of 1980. If there were no rules, fine, they could have enacted that law. Because they have the rules of 1980, so that's why they were not empowered to pass any law which was contrary to it.
I would not go to that extent. Assume there are no rules. The question is whether the parliament can frame this law or not is a question which probably is not free from doubt. I would still say the parliament can't do it. Rules are imperative.
So
if your lordship would look at Article 8, if your lordship would look at Article 8.
इम्तियाज साहब,
Sir.
ये सिंपल हो गया है। आप ये कह रहे हैं कि इस आर्टिकल में एक्सप्रेशन लॉ जो इस्तेमाल हुआ है, this excludes an enactment of the parliament.
No, my lord, I'm not saying this at all. I say law has a larger composition than the act of the parliament.
So we are, at this moment, we are only concerned with an act of the parliament.
Your lordship has asked me a question, what is the scope of the word law? Yes, and I'm trying to assist your lordships.
In this case, it's not relevant because the law has already come.
My lord, I am saying that this law, your lordship's assumption is that since the word law has been used in Article 191, therefore the Parliament can make this law. I am trying to show to your lordship it is not the case.
I'll take you back to my original question.
Please, lordship.
Where under a constitutional power, this court has framed rules. Do they stand on a higher footing than ordinary legislation?
Yes, my lord, there are judgments to that effect rendered by your lordships.
Can I ask a question as well? When the Constitution makes a distinction in different articles using the Act of Parliament and using the word law, so how do you see that distinction? So for example, in 191, they could have said subject to the Constitution and Act of Parliament, but instead of saying that, they've used the word subject to the Constitution and the law. There are other provisions of the Constitution which don't use the word law, but use the word Act of Parliament. So there is a clear difference between an Act of Parliament and the word law. So what do you understand by the word law? Because this provision of making rules is subject to the Constitution and the law.
The framers of the Constitution were conscious of the distinction between an act of the Parliament and the law. While they envisaged that law includes judge-made law and other variations of the law, Act of Parliament was specifically used in a particular sense. And they can't be used interchangeably.
And whether this enactment, Act of Parliament, cannot be considered as law?
Lord,
not a law?
in ordinary parlance, there may be impression.
No, I'm talking specifically
but
about this.
within
Whether
the context of Article 199,
this is not law.
it is the Constitution and law. It would mean law in a broader context. And what are those? Laws which are protected under Article 270AA. Usage or customary practice having the force of law in terms of Article 8, and judge-made law, the judicial precedents which your lordships have given time to time to the people of Pakistan to show to them what law is.
I got your point. You say that every usage, custom can be considered as law, but cannot be considered as act of the parliament.
Yes.
Whereas act of the can be considered as act of the parliament as well as law.
Yes.
So then it is not a law.
I am saying the context in which the word law has been used in the phraseology of Article 191 manifests that this is not an ordinary act of parliament. It means the law which has been rendered from time to time in the form of judgments of the Superior Court.
Do you think or are you arguing that it is the exclusive power of this court under Article 191 to make rules?
Absolutely.
And those rules, once that power has been exercised, whether by specifically making rules or through law that is judge-made law, ordinary legislation cannot override that because there is no legislative competence to do that in terms of item 51.
That is precisely my argument. I will go a step further.
Vicky, before you do that, it's very interesting. I was just recalling the equivalent provision in the Indian Constitution is Article 145 relating to the rules of the Supreme Court. Now this has very interesting language. It is subject to the provisions of any law made by Parliament.
Yes.
The Supreme Court may from time to time with the approval of the President make rules, etc. So here, in relation to law, they are clarifying it is statute law or made by Parliament. Whereas in our case, it is just law. So the rules, the law includes any decision of the court which sets out the practice and procedure of the court. And to that extent, statute law cannot override it, cannot supplant it, cannot whittle it down until the court itself revisits that law on the judicial side. It cannot even be done by the full court sitting on the administrative side. We go back because there is a certain equivalence between what the court can do on the administrative side to make its rules and what Parliament can do maybe in terms of statute law. But it seems to be that use of, speaking for myself, the use of the word law includes case law or judge-made law. Even the full court on the administrative side cannot overrule that. So this rule, which is supposedly overruled by sections 2 and 3, master of the roster, that is judge-made law. And therefore, even the full court sitting on the administrative side can't do it unless the court revisits that principle on the judicial side.
Imtiaz Sahab, how will we read into this provision 191? It's a constitutional provision. We'll have to read into it that the law only means judgment law. फिर अगर आपका आर्ग्यूमेंट ले लिया जाए तो इस लॉ एक्सप्रेशन से enactment is excluded, but even a usage or a custom override a rule made by all of us.
My Lord, my submission is as follows. Allow me, just follow your Lordship's conclusion. My Lord, the Constitution as I read it, and I make submission with respect to your Lordships, the Supreme Court of Pakistan has held that notwithstanding the rules and the rules which are framed under the constitutional scheme, they are on a higher pedestal than ordinary law. Even conventions which have been judicially recognized by the superior courts are constitution by themselves, and the Parliament cannot encroach upon them.
This is next point.
पहले इस fundamental उसको clear कर दें. Do we have to read into the expression law that it is only confined to the judgments of this court and the precedent?
Your Lordship will appreciate the contours of the word law which has been used with reference to the Constitution in terms of Article 181 and the scope of that word. And if your Lordships come to the conclusion that this includes the case law rendered by the superior courts have said that even conventions, if they are proven before the court, in the constitutional domain, they are the constitution themselves and violation cannot take place.
ये जो लॉ है आपके ख्याल में 191 में नहीं आता, ये किस कैटेगरी का लॉ है ये
कैटेगरी सर अनकॉन्स्टिट्यूशनल लॉ है, ये आते ही नहीं है.
In which category you will fall this law, because you
This is
say
act
that
of the
Article
Parliament.
191 the definition of law is something else which you are trying to
This is an
argue.
act of the parliament. It comes out of the theme of the word law, and there are other sources
How
of
it
law.
is out of the word scheme of law? What is your argument on this point?
My argument is that to isolate the word law with reference to act of parliament alone.
What about Article 140 and 141, where is also the word law has been
Yes,
used?
what I'm saying this is that Article 141 and 142.
Article of the Constitution in which the laws are made by the Parliament.
My
And
lord,
under Article 141, the law is mentioned. If it is not the law, then what is the category of this
My
law?
lord,
Because we are
Article
going to develop a new jurisprudence
No, my lord.
in this case. The
Article-
third category of law.
Article 141 has to be read with the fourth schedule, and it cannot be read in isolation. What it means is that these are the laws which will be enacted through act of parliament.
No, if you will read Article 142, if you will read Article 142,
सिद्दीकी
the
साहब
Majlis Shura,
सिद्दीकी साहब अगर कॉम्पिटेंस की बात है ना, कॉम्पिटेंस की अगर बात जो बार बार सवाल हो रहा है, तो एंट्री 55 और 59 को पढ़ लें, तो उसमें तो पावर है ना कि पावर्स लॉ आ सकता है.
सर लॉ एनलार्जमेंट के लिए फॉर
आगे
एग्जांपल
पढ़े ना, सप्लीमेंट्री पावर्स भी दे सकता है.
सर ये सप्लीमेंटल पावर नहीं है,
ये बहस आप
ये
कर सकते हैं.
इंटरनल वर्किंग को इंटरफियर किए जा
हो
रहे हैं.
गया, तो आप ये बहस करें ना कि ये सप्लीमेंटल पावर्स के अंदर है या नहीं है, या एंसिलरी पावर्स के अंदर है कि
सर,
नहीं. आप तो कह रहे हैं लॉ ही नहीं बना
तो सर मैं बताता हूँ, मैं आपसे कह रहा हूँ कि अगर ये लॉ ये हो कि आपको फॉर एग्जांपल इलेक्शन एक्ट के तहत डायरेक्ट अपील दी जा रही है सुप्रीम कोर्ट में या सर्विस मैटर्स में दी जा रही है, तो वो इनलार्जमेंट ऑफ जुरिसडिक्शन दी है, लेकिन आपकी इंटरनल वर्किंग के अंदर लॉ फ्रेम नहीं हो सकता.
देखिए ना, एक सेकंड, बड़ा सिंपल सा सवाल है, अगर हम फोकस कर लें तो बड़ी जल्दी मामला हल हो सकता है. एक तो ये है कि लॉ इन्विजिज किया 191 ने, तो कानून आइन रिडंडेंट नहीं होता, कुछ चीज कानून ऐसा हो सकता है. उसी आइन के अंदर लिखा है कि 55 में सप्लीमेंटल पावर्स दे सकता है, 59 में लिखा है और एंसिलरी मैटर्स भी देख सकता है. अब आपने सिर्फ हमें ये बताना है कि क्या पार्लियामेंट ऐसा कोई बना सकती है 55, 59 और भी शायद एक आध प्रोविजन एंट्री के तहत जो रेगुलेट कर ले अफेयर्स ऑफ द सुप्रीम कोर्ट.
सर
क्योंकि 191 इन्विजिज करता है कि ऐसा कानून हो सकता है, तो सुन लीजिए, तो वो कानून रिडंडेंट तो लफ्ज नहीं हो सकता ना. 191 में एक कानून ऐसा हो सकता है कोई जो रेगुलेट करे प्रोसीजर को, उसकी पावर 55 और 59 में दी हुई है. आपका ये बहस हो सकती है कि सर इसमें वो पावर नहीं निकलती फेडरल गवर्नमेंट, फेडरल लेजिस्लेचर की, वो आप बता दें हमें बस सीधा.
सर दिस item 55 first makes a prohibition.
वो हमने पढ़ लिया. मैं आखिरी
सर
लाइन की
मुझे
बात,
आपने पढ़ लिया है, मैं भी सारी जिंदगी आई हैव बीन रबिंग शोल्डर्स विद लॉर्डशिप. This creates an impediment on the word jurisdiction and power.
वो आगे
इसके
भी
ऊपर
मिला
तो
के-
फुल स्टॉप है.
इसको पूरा पढ़िए ना, मिला
सर,
बिट्स एंड पीसेस बिट्स
सर
एंड
मैं दोबारा पढ़ूंगा तो वो कहेंगे कि दोबारा पढ़ रहे हैं आप.
नहीं, इसमें आगे जाके
Jurisdiction and power of all courts except the Supreme Court.